Hello, my name is Brian Spector. I'm an Arizona business and bankruptcy attorney. Earlier this year, the law changed to make it easier and more affordable for small business debtors to restructure their debts in bankruptcy. It's called Subchapter 5. It's still a part of Chapter 11, but there are some important differences. Before we get to those differences, let's discuss eligibility. To be a small business debtor, one must be engaged in commercial or business activities, not including the ownership or operation of single asset real estate. And the debts have to be less than $2.725 million, at least 50% of which came from commercial or business activities. Now, important note, under the recent CARES Act legislation, that limit increased to $7.5 million, but only for 1 year. Either an individual or an entity, including a corporation or a limited liability company, can be a small business debtor. If the business is conducted through the entity, then the entity and an individual owning 20% or more of it each can be a small business debtor under Subchapter 5. To highlight a few of Subchapter 5's differences from Chapter 11, only the debtor may file a restructuring plan, and generally that must occur within the first 90 days of the case. Secondly, unlike Chapter 11, a trustee is appointed in every case. The trustee helps to facilitate a consensual restructuring plan and also serves as a conduit through which creditor distributions are made. Now, Subchapter 5 contains several new advantages, and I'm going to highlight 6 of those. Number 1, the debtor need no longer prepare and obtain approval of a disclosure statement as a prerequisite for filing a restructuring plan. Number 2, the rights of holders of claims secured by the debtor's primary residence can be modified if the debt was used primarily in connection with the debtor's business. This provides a small business debtor with greater flexibility to, say, address an SBA loan guarantee secured by the debtor's home. Number 3, the absolute priority rule no longer applies in Subchapter 5 cases. This is important because that rule used to give creditors near-veto power over a restructuring plan. So now the debtor has greater bargaining position, and in addition has a greater opportunity to retain its equity interest in its business. Number 4, a consenting impaired class of creditors is no longer needed to confirm a plan. The plan does, however, still have to be fair and equitable and meet the other confirmation requirements. To be considered fair and equitable, 3 years of projected disposable income have to be used to fund the plan, and as many as 5 years if so ordered by the court. Number 5, as a general rule, no creditors committees are appointed, and number 6, no U.S. trustee quarterly fees are payable. So there you have it. Understand that Subchapter 5 is elective, so it's important to consult an experienced bankruptcy practitioner to determine which type of filing is right for you. The bottom line, however, is that Subchapter 5 does provide a small business debtor with a more convenient, easier, faster, less expensive way to restructure debts in bankruptcy.